Quick disclaimer before we get into this. I am an intellectual property attorney, but this video is not legal advice, nor does it create an attorney-client relationship. A lot of these thoughts are my own. I believe what limited things I'm going to be sharing constitute fair use, and I'll explain in this video, but just wanted to kind of get that disclaimer, that necessary disclaimer out of the way. On with the show. If you've spent any amount of time on the internet, there's no doubt that you formed an opinion on copyright law. In fact, I'm pretty sure all of us have some opinion on copyright law. But I think the issue that I see in most of those discussions is that what's taught, like the information base that all of us share to discuss the topic, is either misinformed or incomplete. Now, I'm not saying all of us need to be intellectual property attorneys to have a fruitful discussion on copyrights, but I do think that we all need to have a shared understanding, something that's close to what us copyright attorneys deal with on a day-to-day basis. Because at the end of the day, the only people that are interested in having a discussion like this are people who utilize copyrights on the day-to-day, creators, but also just people, denizens of the internet. Copyright attorneys, I've noticed in my experience, generally don't have much of an opinion, interestingly enough. Obviously they're competent enough to be able to discuss it and discuss the matter in depth, but usually when I talk to them, asking them like what they think about the term of a copyright, or why should creators be allowed to just hoard intellectual property without using them, is that the right course of action? Many of them don't have an opinion, and I think the reason for that I think there's a few reasons for that. The first is attorneys are busy, right? They're swamped with work. They often don't have the time or luxury to really be critical of the law, let alone the law that they benefit. That's kind of the second reason, right? Because no doubt many of you know that copyrights are extremely litigious. Attorneys love copyright litigation, and one of the reasons why is because, assuming it's done properly, we can recoup attorney's fees if we win the lawsuit. Sometimes even if we think we're really going to win in settlement, that can also be included in the final settlement, right? Is the recoupment of attorney's fees. So we love them, very lucrative. And the last point, I think, is attorneys in general are very much, we spend so much time understanding the law, and then we kind of go right into how the law is applied. There's not really much room to analyze the law itself. Unless you're going into legislation drafting, you don't really have that, you don't really stretch those muscles of kind of critiquing the law. You just kind of go to, here's what the law says, here's how it works, here's how I apply it. And so I think a lot of people, they just don't form an opinion. And that's totally fine. But I noticed that once I talk to fellow attorneys, first of all, it's just to be clear, it's only fellow copyright attorneys, people who are familiar with copyright law, because other attorneys, they don't have any basis. They don't have an information base, kind of like everybody else, about this subject. But when I talk to other copyright attorneys, they'd be like, I didn't think about that, or that's a good point. And it's like the first time they ever thought critically about it. So I think all of us can kind of benefit from having both a point of, again, kind of like a shared knowledge base, so that people who do want to discuss and critique copyright law can competently, and also just to kind of, give my fellow colleagues out there the ability to maybe review some of these positions on the law, and just so we can have more fruitful discussions. Because at the end of the day, as things currently are, I do think there are a lot of problems in copyright law. And I think the system requires a massive a massive overhaul. That's not very much a hot take. I know others talk about getting rid of copyright system altogether. I don't have that extreme of an opinion, but I do think things need to change given the current digital media landscape. And if they don't, things are already bad as it is, and it's just going to get worse, especially as more and more intellectual property falls into the hands of just a few number of rights holders. This video is probably going to be titled something like "The Problems in Copyright Law" or "The Copyright System is Broken. Let's talk about it," or something along those lines. I haven't really decided on that, but as much, and I don't want to say that I'm coming off as like clickbait or anything like that, but again, just to kind of give us that shared understanding, I've decided to break this video up into two parts, just because I don't think any of us want a 2-hour or 3-hour long video, because I could talk about this stuff all day. I'm trying to be as concise as possible. There's chapters down below that's going to divide us up by topic. I have an outline just to make sure I'm on point on some things, just because there's so many things I could fall in the weeds on, and every chapter that you're going to watch is literally a chapter of a copyright textbook that you would have in law school. It's not, I didn't look at any, it's like, I just know that the topics, like from the textbook I had when I was in law school, it's definitely, when I was done with this outline, it definitely was reminiscent of that. So all of these could be a whole day of lecture. It's 3 hours per chapter, right? So like, this is definitely a truncated version. But because of that, this video is already gonna be pretty long, just kind of touching on how the system, what are copyrights, how the system works, and a lot of nuance, because there are so many copyright, like there's so many intellectual property 101 videos, copyright videos, how do copyrights work? There's so many of those. I'm gonna touch on things that they say, but I'm gonna go probably way more in depth than any of those do. And again, I think that's necessary because in part 2, where I do talk about the actual problems and how to fix them, there'll be things that I mention in this video that I will bring up in that video, both as saying like, here was the thing that I described in part 1 and why it's a problem, and here is this other thing that I briefly mentioned that I think is really good and should be applied here, here, and here, right? So that's kind of why I decided to break this up this way. I originally was gonna have a part 3 where I did this solution separately, but I think I can combine those into a single video. We'll see. So again, I didn't want to clickbait any of you guys, but I do think it really is necessary. It's very crucial that we just discuss the system and how it works in this video first before we get to problems and solutions. All right, so what are copyrights and why should we care about them? A copyright is a form of intellectual property that specifically relates to creative works. So sciences, inventions, anything relating to business and trade, like those are their own separate fields of intellectual property. A copyright gives you essentially a monopoly on your artistic and creative material. So hundreds of years ago, when the first copyright laws were being put on the books, our ancestors had this really bizarre viewpoint that unless we give artists a monetary incentive, they're not going to create anything. And we value the arts. We value the arts as much as we value the sciences, right? That's, culture, technology. I don't know where they got in their heads that you need a monetary incentive. Humans have been making art for the sake of making art since, you can go back to cave paintings in the Stone Age, right? You don't need an excuse to have art be made. But I do think there is value in having this monetary incentive, right? If you are an artist and you want that to be your profession, you need to be paid. And having that limited term monopoly on your intellectual property does help incentivize you to make more things so that when they eventually go into the public domain, we now have a lot of artwork that we as society can enjoy. And in that amount of time you had your valid copyright, you've theoretically racked up a bunch of money and you're now living happily. Right? That's how the system, broadly speaking, was designed to work. To get a little more specific, you are granted 4, 5-ish exclusive rights to the creative work that you've made. You have the exclusive right to reproduce, that copy, the exclusive right to distribute, the exclusive right to publicly perform or display, depending on what the work is, and the exclusive right to create derivatives. Now, we'll talk about derivatives later. That's a whole topic on its own that needs some time. But I think these all make a lot of sense, right? I wrote a book. I want to release the book and sell it to a general audience. So I'm going to go to a printing press, old school, make 1 million copies, just copy it, sell it, distribute it, and hopefully when it gets turned into a stage play or something, I can reap the royalties on that. That's a derivative, and it will be publicly performed. So all of the things, all of the ways that you can imagine exploiting a work, for lack of a better term, you have exclusive rights on. Now you might notice that there is a notable omission in those list of rights that I think a lot of people just assume you have if you have a copyright. There is no right to creditation. The framers of the law of copyright law, of the Copyright Act, specifically in the United States, but I think this is true elsewhere in other jurisdictions, they look at intellectual property like any other form of property, like a personal property. Like if I bought a laptop from a store, right? I don't need to carve my name onto it. I think most people don't do things like that. And so you have this situation where artists assume that they will always be credited for the work that they make, whether it's making a song or writing a book, even if it's like a work made for hire, and we'll get into that later. Even if the right on creation goes to a company that hired you, I feel like most people assume that you're just going to get credit for it, and that's just not the case. And again, I think the issue kind of comes from where the law and the lawyers who drafted the act kind of just treated intellectual property like any other form of property, and it's like, well, why should a guy who made a table that he sells it to you need to have his name on it, right? It's just like you pass the title over to somebody else. Now they're the owners. All we care about is who is the current owner. We don't really care about who was the previous owner, and even the first owner, the author, right? Speaking of authorship, that's just kind of the general term, by the way. It kind of refers to, it doesn't matter what the work is, the creator, if you will, is the author of the work. Speaking of authorship, in order to get a copyright in something, you really have to have 3 elements for it. So you need to have authorship, you need to be a human, so no AI, no animals. There's a famous series of cases where a monkey took a selfie, or an elephant was trained to paint with its trunk. Those are all public domain out of the gate because there was no human authorship. So you need to have a human author. It needs to be you. So that's the authorship element. 2, it needs to be creative. Now, what do I mean by creative? It doesn't need to be wholly original. Like, you don't have to come up with a plot line or that nobody has ever come up with before. But it has to, in fact, the bar of creativity is really low. The best example I can give is that phone books, if they're arranged in a weird way. So like if you take a list of people in a town and you don't arrange it by name or address or anything that would make a logical, like, no creative sense, but you did it by longest name, like the number of most characters or something weird like that. And then followed by phone number or something weird. That arrangement is copyrightable. Notably, the information itself isn't. Facts are not copyrightable because there's no creativity behind them. But just that arrangement is copyrightable. And so, like, you are protected to the extent you have creativity, right? So, to put it another way, you have protection as great as the amount of creativity you put into a piece of art. The example I always like to give for this is, let's say you find a really breathtaking cliff that has an amazing scenic view and you take a photograph at sunset, right? And you post it online. Your copyright is extended only towards the photograph that you took. Because I can go out to that cliff and I can take my own photograph of a sunset that I see. And it could look almost identical to yours. In fact, it probably look very darn similar. But I didn't copy your photograph. I took my own. And because of that, you have a valid copyright in your photograph and I have a valid copyright in my photograph. Now, that doesn't mean infringement is only limited to direct copying. In fact, we'll get to that when we get into infringement. We'll talk more about that and how there's this thing called substantial similarity. It doesn't need to be direct, literal copy paste. But again, you're pretty limited in the image in terms of literally how it looks, like pixel by pixel almost, for a copyright like that. The more creative you get, the more protection you have. If you make a scene through some form of CGI and a green screen and you arrange this space, well, now all of a sudden things are a lot more protected, right? The different elements that you put into the scene, those are all generated theoretically by you. And, you know, while someone could cut, like, let's imagine again me posing on a green screen and then you putting in me in space with a spaceship battle, like I'm floating in space and then there's like a starship battle in the background and those are all your assets, you made those, right? All of that, if anybody tried copying that, obviously it had to come from you. They had to replicate what you did. Sure, somebody could kind of cut me out, but again, that's still your photograph. They would have to ask me to make the same pose, take an independent photograph, and then that part. But again, that you still arranged how I would be. Like if I were making a pose like this, you had to tell me to do that, right? So even the photo of me is, protected. To have somebody even come up to me and recreate the photo themselves, that's copyright infringement. So it's not just direct copy and pasting from a file or from a source, but again, you have the more creative it is, the more protection you got. And then the last element of a copyright is you need fixation. So no art that exists in your head is copyrightable and protected. It has to be fixed in a medium. So let's say you have a great idea for a movie and you want to tell everybody about it. If you tell your friend who happens to be a movie director and he loves your idea so much, and to be fair, you've been thinking about this movie for years, and you have all these characters named out, you know exactly who's who, you know the plot beat by beat, you regale him for hours, and he's enthralled, and he says, that would be a great idea for a movie. And he turns around and he makes that movie. You didn't have a copyright because you did not write it down. If you are a script writer in such an instance like that, you need to write it down somewhere. It doesn't have to be physically like pen to paper, right? Like a Word doc or a PDF. And digital stuff works too, but it just can't be locked up in your brain. That is not fixation. So if you have authorship, creativity, fixation, bam, you have a copyright. And you don't even need to publish it either. As soon as you make the thing, it has a copyright. Although you're gonna want to publish it for reasons, we'll get into that later. But yeah, it's that simple. The current copyright law makes it so that the second you make anything that's creative, by make it I mean, fixed it to a medium, you have a copyright now. I say you because again, I'm assuming you made it by yourself and you didn't make it with anybody else, and you weren't hired to make it for someone else. If you made it with a couple of people, you are both joint authors and you both have equal rights to the entirety of the final product. So let's say I'm a lyricist and my buddy James, he's really good on the guitar, and we make a song together. I don't have rights just to my lyrics, and he doesn't have rights just to the melody. We both have full rights to the whole song and its components. So I think that's another thing that people need to really kind of be aware of. And then similarly, there's this whole thing called work made for hire. Most contracts will say if it's a work made for hire or not, in which case the person who's doing the creative work is voluntarily giving it up for the person they're making it for, usually a corporation. But there's such a thing as implied works made for hire. That is a whole can of worms that I'm not going to really get into right now. But even if there is no contract, written contract, there can be implied contracts that would include a work made for hire, sort of like an implied element. It's very clear I hired this person to make this thing for me. And even if there was some oral agreement that there was some understanding that this is I'm the one that has the rights in it, right? Then that's a work made for hire, and the author has no rights to the work. That's it. All right, so you've made so let's say you've made a creative work and you now have a valid copyright in that work. You did all the things, you got a copyright. Well, now what? Your copyright, assuming you're an individual, is your life plus 70 years. If it was a work made for hire, then it is a flat 95 years until from the date of creation. And if it's joint authorship, obviously not obviously, it is the life of the authors, so the last one to die, and then it's 7 years from that date. So and once that term lapses, the work is then entered into the public domain. What does that mean? So if a work is in the public domain, that means anybody can enjoy it, use it. All those exclusive rights that I talked about, those four or five, how you want to count it, exclusive rights I talked about, anybody can do them. You can copy them. You can sell them. You can perform them. You can make derivatives off of them. I think that's part of the reason why we as a society really care about the public domain so much, is because when none of the creative works are in the public domain, it really does force everybody to sort of become authors. So even people who aren't creatives, who don't do this stuff for a living, we kind of have to all follow the same system, in that you all have to make something. We all have to make something creative on our own, not based on anything else, and fix it to a medium, right? Just like people who made the original work that we were talking about earlier, right? So the last thing I want to say on this point before moving on is and I'll just want to say them because just to let you know that it's a thing. We'll talk more about this in part 2. It is possible to publish your works anonymously or pseudonymous, or even under a pseudonym. And it's also possible for things to just be published without anybody knowing. Again, kind of an anonymous work, it's possible that it wasn't originally anonymous, but the tracks on where it originally was first published got lost, and so nobody knows who the author is anymore. Those are orphan works. It's kind of a similar question of, if a tree falls in the forest, does copyright still attach to it? The answer is yes. These works all have, assuming they were made under the current law, they all have the same terms as everybody else. So I'm not going to go any deeper than that, but I just want to let you know that is a thing. All right, so you have a term. So you have a copyright. We know how long it is. What about specific examples of copyrights? So let's talk about music. Some of you may already know this, because I feel like this is like the biggest form of copyright trivia people kind of like to share. But every song that you hear, whether it's on the radio or on streaming, every single song that you've ever heard, pretty much probably your entire life, there are 2 valid copyrights in it. There is the composition, that's anything that you could write down. So lyrics, melody, like the song as it is transcribed, essentially. And the sound recording, what your ears are actually listening to. And those are separate. And the reason why that they're separate is a long, complicated history involving the music industry and lobbying Congress, and it's a whole thing, right? But as a result of that, you need to be aware that when you make music, or when you're dealing with music, there are different ways that infringement can bear its head. So sampling is a very common practice, especially these days. And I think people just assume that that's a thing that you can do. It isn't, unless you have a license for it in the sound recording that you are sampling, I mean, right? So it's actually really funny how they of all people recognize this first, but it did cut into their business, so I get it. But the record labels realized pretty early on that unless they had a system that allowed for each other to kind of be able to press each other's music that they had the rights to, it would really fracture the music industry into just a couple of players, and none of them would have access to each other's libraries, essentially. So there's the system called compulsory licensing. Compulsory licensing says that you can make your own phonographs of a composition. Let me break this down. So again, there's 2 copyrights, right? There's the composition, the music score and the lyrics, and the sound recording. So this is not dealing with the sound recording at all. We're dealing with the composition. I can form my own record label today, and let's say I really like Landslide by Fleetwood Mac. I love that song. I want to make, DVDs of that song. I want to put that song on streaming. But I don't want to share Like, I don't want to get paid a license for it. They might not grant it to me. I want to just do it. So how this works is, under the compulsory licensing system, I can take the composition and either do a cover of the song myself or hire somebody else who sounds like Fleetwood Mac to do a cover. And from the sound recording that I now have made, I can now make, they call them phonorecords. That's just a general term to describe, vinyls, CDs, MP3, digital files. Any way that I'm allowed to make my own sound recording from the composition, so long as it's not the sound recording that came from that composition originally, right? So as long as I don't use Fleetwood Mac's version of the song, I can sell it, provided I record it myself. That's not basically allowed for covers to exist as they do. And so while sampling is not okay, if there's a beat that you like, if you make that beat yourself, so again, you recognize how that beat goes and you replicate it independently, you didn't rip it from anywhere. So long as you pay that, you put them on notice that you are getting a compulsory license from them, and you pay them monthly for every, and it's a small cut of all the earnings you make from the sales, or I guess in most commonly now streaming, of the cover that you've made. As long as you do this regularly, there's nothing they can do about it. There's no infringement. There's no lawsuit. They get their money. You get to enjoy the cover that you have made and are now enjoying. Still on music, because this is probably the most confusing section of copyright law. And this kind of ties into another area of intellectual property in general called licensing rights, contractual. It's basically contractual rights is kind of what I want to call this section, because when we talk about those 6 exclusive rights, and just kind of a reminder, distribution, reproduction, derivatives, display, perform publicly. While those are your exclusive rights in the intellectual property, you can segment them out and you can get very specific with it through contracts. So what do I mean by that? Well, again, historically, when a song was first recorded, it was recorded on what was called the master recording, right? And it was from this plate that has basically the full recording of the song, and it's in the highest quality that you can have. It is from this master plate that vinyls were literally pressed onto it, and that's how you made the vinyls that you then sold in record stores. So what we call rights to the master, again, it doesn't really make a lot of sense today with digital, and how a digital file that you first make and then share around is all going to be the same, usually the same high quality. But we still identify that first originating file, and any subsequent publishing that comes from that is very valuable, right? Because if you hire somebody to put your music out there and market it, you want to have the rights to all of the sales, all of the streams, if you're the author, if you're the artist, I mean. So that's where the idea of, so that's where you often hear master rights, and like a percentage to the master kind of comes into play. And then publishing rights are kind of a subset of the master, comes to DVD, CD sales, MP3 sales, streams. That's all publishing. It's kind of like umbrella is the master, and then of that is publishing rights. And then there is a separate component called synchronization rights, and that's where you take the sound recording from the master and you use it to sync it to a music video, or you sync it to a movie, or it's in an ad, or it's in the background of a YouTube video, right? Or in a TikTok, or in a Instagram reel. Those are synchronization licenses. And that is a separate contractual right, essentially, in terms of how that sound recording is used. And then finally, there's just the public performance element of it. That's the last element of, that's like the last form of the master. That's like if you're in a mall and you hear on the speakers like the song that you've made, right? That is another form of licensing rights that kind of came out of contracts. And just kind of to hit the point home, I'll use this as an example. Famously, Marvel sold just the film rights to Spider-Man to Sony. They retained their rights of the comic books, television, any other like rights to the character they retained to themselves, and that went over to Disney when they bought over Marvel. But Sony kept the movie rights for a long time. I don't know if they still do. So you have a copyrighted story, comic book, Spider-Man, the original incarnation, right? It's copyrighted. You have derivatives, sure. TV, film, cartoons. The law doesn't care. Like, the law sees it all as you have the exclusive right, those 5 exclusive rights to both the thing and all derivatives of it. But you're able to segment that out and give separate licenses as you see fit. I think I'm finally going to get to. I kind of danced around it, so let's just kind of talk about derivatives really quickly. And this, I think, a lot of people don't really seem to understand, is that intellectual property extends beyond the thing that you made sometimes. So let's say, and again, it kind of goes back to that idea of the more creative it is, the more protections you have. So let's say let's say I make a comic book, right? And I'm creating a story about, and let's just say I authored Spider-Man. Let's say I'm Stan Lee, and I authored Spider-Man. I wrote the comic books for Spider-Man, and I did that for a period of years. So I have a series of comic books, so you know who Spider-Man is, you know the stories that he goes through, you know what he looks like, right? All of those elements you now have of the character that is Spider-Man. When I say a derivative work, I mean the law gives you essentially the opportunity, like it gives you the opportunity to do other things with the creative work that you've made. Using Spider-Man as an example, I can now make an animation of it. I can now make a live action TV show of it. I can now make a film of it. I can make a stage play of it. That it gives me it gives me the opportunity to make those things. And so anybody else who, because like if you think, oh, Spider-Man's just a comic book, he never made a movie, a live action with humans. Like again, I don't look nothing like Peter Parker. I'll be Spider-Man, and I'll have my friends shoot the film, right? It won't be official, but I will have, I'll be named Peter Parker, I'll be Spider-Man, I'll fight against the Green Goblin, and we'll makeshift some armor that kind of vaguely looks like it, right? The law, even if Stan Lee had no intention of ever making a film, he had the right to do it. And I had to seek a license from him to make a movie regarding that subject matter that he created. This extends as far as you want to go. Let's give another example. If you're familiar with video games at all, there's a really famous series, I don't even know how I have to say this, Legend of Zelda. I think we all know what Zelda is. But some of the most recent games involve cooking mechanics. And there was a whole crafting system regarding making recipes and cooking and whether or not it was successful. And some of those have become really iconic online. And so somebody, and you can look this up, made an unofficial Legend of Zelda cookbook. Nintendo probably was never going to make a cookbook, nor did they probably want to. I don't know if this person got a license from Nintendo, but I'm going to assume that she didn't because it says it's unofficial. Is that even if she makes full recipe, it doesn't use any images from the game, but she titles them similarly to recipes that you can make, and she comes up with her own recipes that will have probably the food probably tastes delicious, right? But it's all kind of got like a zeal to kind of make it, again, the final product is going to kind of look like the final, like if I'm making a cake, it's going to resemble vaguely the cake that I made in the game, right? And that's, she put all that hard work and soul into that. And again, Nintendo has no interest in making this product at all. Nintendo had the right to make it. And similarly, she had no right to make it, except with permission via a license, which would be contractually have some level of like percentage rights of royalties, and how does that work, right? So she was in the wrong, theoretically. Again, this is kind of just, we're talking hypothetically here. I'm not assuming I know the details on it, but again, I'm assuming she didn't do it without a license. It looks like a derivative to me. I haven't bought the book, so I don't know what the images are in it. But again, assuming it's all even just her photographs of the stuff that she made from the recipes that she wrote, as long as they resemble the stuff that's in the game, there's a lot of ifs, right? Arguably a derivative of The Legend of Zelda, and that's infringement. It's kind of weird to think about, right? So, speaking of weird, one last weird point, odd quirk of the system is that you can copyright trade secrets. Now, trade secrets are their own area of intellectual property. The name implies, that's kind of self-explanatory, like the famous Coca-Cola recipe or the recipe for KFC, how they season their chicken, right? These are like these are trade secrets. Like they're under lock and key. Nobody knows except like the higher ups in these companies what those are. But instead of another great example, this is where it comes up in my form of practice, software. Software companies are highly protective of their source code. But in the off chance somebody, runs out with it, they want to be able to sue them for copyright. And so in order to do that, and we'll get more into this detail later, they need to register it. But they need to register, and that involves giving them a copy of their thing. And so what they'll have to do is redact heavily their copyrighted source code in order to be able to enforce it as under copyright law, essentially, if it ever got out. So yeah, trade secreted stuff, 100%. If it's creative, 100%. If it's put pen to paper, it's creative enough and it's got an author, it's human, 100% can be copyrighted. All right, so I think we established what copyrights are. We talked about how the system works. Let's kind of go, and I touched on this a little bit. Let's go deeper into infringement. All right, so what does it mean to infringe on a copyright? So there are two elements to infringement. First, you need to have a valid copyright in the creative work. We talked about that in the last part. The second element is there needs to be what's called unlawful or illicit copying. So absent me saying, yeah, I really liked this artwork this digital art that you made, I 100% right-clicked copy, right-click pasted, put it on my website. Absent an admission like that, you can infer copying, by saying that I had access. It was on your blog, publicly accessible, and it was posted before I posted mine, and that is substantially similar. In this case, it was literally like it's direct copying, right? It's 1-to-1. There's no question of that. But I want to get into substantial similarity because I do think it is a discussion worth having. Now, there's a whole. I can't really do how content ID system works. I can't really do on the music side, but there's some really interesting lawsuits on music infringement and whether or not they're substantially similar. And those are some really interesting cases, and I encourage you to kind of Google those. Instead, I'm going to present you these two posters for a video game. I feel comfortable showing these because, and we'll get into fair use and I'll explain why it's this fair use in my professional point of view. But it really is, I think, a great example of this substantial similarity component. I want you to specifically take a look at just the general, literally I'm putting them up, hopefully, side by side. I want you to look at the one at the top, look at the one at the bottom. The one at the top, Horizon Zero Dawn, came first. The one at the bottom, Light of Motiram, came afterwards. Sure, no tracing. Sure, there's no tracing. But even if there was, obviously there would be worse if there was, but it's more, of course, it's more obvious if it were. But even if there was no tracing, and just the fact that I'm copying the different elements that are in the first post, right? You could see how I painstakingly, let's just say I made this poster for the second one, right? I painstakingly, looking over at the one on the left, and I'm drawing, the sketching as much as I can. I'm copying it, right? Now, I'm not saying that references indicate substantial similarity. This is a factual question for a jury to decide. But I'm trying to illustrate here that it doesn't have to be 100% one-to-one. Substantial similarity is a fact-based question. Maybe you disagree. Maybe you think that it's different enough that there is no substantial similarity. And that's totally valid. I chose this one because I think that it is. I think it's a good example of it without one-to-one direct copying. But it is on the cusp. It is totally, I could totally foresee a jury come back and say, no, there wasn't, it's different enough, it's not substantially similar. Because again, there is no guidelines other than what a jury decides that means. What is substantially similar? That is for the jury to decide, is it too similar? Is it substantially similar? That is for the jury to decide, and they could totally foresee a jury come back and say, no, that was not substantially similar. Here's another weird example I'm going to throw your way. This is, I got permission to use this photo. I know the people that are in this cosplay here, but is cosplay infringement? Is this photo an infringement of Spider-Man and Into the Spider-Verse? That doesn't seem right? Like, they, maybe they bought the costumes, but even if if they went out of the way and made the costumes themselves, like, they're in the real world dressed up as these characters, that they're not, what, like, is it just the photograph? Like, if I were a professional cosplayer and I'm in this bodysuit, right, and I'm making really good poses and, it's professionally done, how is that different from a fan-made, how is that different from promotional material of a fan-made Marvel film, a fan-made Spider-Man film? We all are in agreement that a fan-made Spider-Man film that's going to have very similar costumes to these, probably better. But again, we're talking about a professional cosplayer who, a theoretical professional cosplayer that would probably be comparable to that of like a film, right? They're making, like, their promotional photos would probably be very similar to a cosplayer's promotional photos. One's tied to a thing that we 100%, but like the photos themselves feature Spider-Man without the permission of Marvel. Okay, so the photos could be potentially infringement. What about if I'm again, assume I'm in this cosplay. What if I'm walking around? Nobody takes a photo of me. Just the act of donning a cosplay. Is that infringement? I don't know of any cases that go over this, but I think just based on just the law, the black letter law as I've kind of laid it out, right? It was a valid copyright in Spider-Man, specifically Miles Morales as Spider-Man, as it's depicted. Valid copyright owned by Marvel. The person obviously didn't have permission. They had access to it because they saw the movie. They substantially similar, right? Is clearly Miles Morales as Spider-Man that this person is cosplaying as. That sounds like infringement to me, and I don't really see a defense. We'll touch on defenses in a bit, but it's really not fair use. In fact, the posing suggests it's not fair use, right? Like they're mimicking the use. If it was like they're at a convention on like comic books are awful and why Spider-Man is the worst thing that's ever come. Like, and I love Spider-Man, but again, if they were hypothetically doing something that's like in an event that is hyper criticizing the thing, such that the performative air of dressing up as Spider-Man was critiquing it, I don't really see a fair use defense here either. And then the last example I want to kind of give is streaming. So let's say I make a walkthrough of a video game, or I'm streaming playing the game. Is that not infringement? Well, it depends on the game, I think. There's very limited little to no case law on this either, but if it's a very linear, I think if it's a very linear game where all of us are making the exact same choices, and we kind of goes from point A to point, it's literally an interactive story almost. I think there's a very strong argument that there is no, that it's copyright infringement and no defenses to it. If I'm critiquing the game while I'm playing it, and not just giving tips or tricks, but I'm talking like I'm a budding game developer, designer, and I'm like actively critiquing the game as I am playing it, that probably is fair use. And if it's a sandbox game, something like GTA or Minecraft or something like that, and I'm adding my own creative elements to the game, that, so I'm not doing like the main missions of GTA, I'm not beating Minecraft, I'm doing like a sandbox like creative mode in it. Maybe I'm adding my own mods into the game, and I'm doing something really creative in that space. That's probably fine. But I'm not going to say 100% that bright line rule like that is 100% fine, right? We'll get into fair use in a little bit, but just keep in mind, streaming under the black letter law probably is probably 90+ % of cases, probably infringement. All right, so still on the topic of infringement, let's talk about the DMCA. So the DMCA, or the Digital Millennium Communications Act, was really kind of engineered for a group of, we'll call them platforms. So platforms and publishers are very different in the eyes of the law. A publisher involves, so let's kind of look at this historically. A publisher of a magazine, right? If I had a magazine and I'm publishing it either digitally or physically, and I do a monthly magazine, there is an editorial process, right? I decide whose columns are going to be in the magazine, assuming I'm like the lead editor. The company is going to green light those columns, and then they ship them out. So if there's any defamation in those articles, I'm on the hook for it. Makes sense, right? The question comes from where, at the early days of the internet, there were these forums and bulletin boards, and people were sharing a whole lot of copyrighted stuff. So like the full texts of books, the full like ripped DVDs were going on these bulletin boards. You could find anything at this very early stage of the internet. And these platforms these bulletin boards were just being like, hey, there's no moderation here. I didn't say or approve of all this copyright infringement that's coming on to this bulletin board of mine. People just make accounts and they just post stuff. Why should I be on the hook for that? And Congress agreed, and that's where these called the safe harbors of the DMCA kind of came into place, where if you are a platform, because normally the whole thing with copyright infringement, there's this element called secondary liability or vicarious liability, where if you're inducing people to commit or you're making it easier for them to commit infringement, you're on the hook for it too, right? And these platforms often had decent money, especially if they were like a subscription thing, or if they had advertisements on it. They would have more money than the individual person probably who would post a random thing, like a random video that they had. So they were worried, and they were rightfully on the hook for this kind of stuff. And so that's where these safe harbors came into play, where if you're a platform, not a publisher, if you're a platform and you don't moderate, you just let users do what they do, you will not be on the hook for infringement if you have a system in place to allow people to issue notices that they're the rightful owner and request the takedown of the item that they see on the platform, and you comply. We're Gucci, right? Like the platform is fine. The person who posted the infringement, they're still on the hook for infringement, but these platforms needed the safe harbor in place to be able to operate. And YouTube is like the biggest, it was and still is the biggest purveyor of content, by far. And there was, at the early days of YouTube, a lot of copyright infringement on it. It benefited greatly from the DMCA, and it still does today. And there are all types of new features that it has that kind of circumvent it, but the DMCA is still there. People who are copyright rights holders can still request, and they call them copyright strikes, can still request a video to be taken down if they think that their work has been infringed. So that's the DMCA and how that kind of works. And it was really necessary for platforms to be able to maintain their existence, essentially. Before we move on to fair use, I just want to mention a couple more things relating to infringement. The first one is intent. Does intent matter? And the answer is no. Copyright law is what's called strict liability. That means we don't care if it was purposeful or not to show infringement. I mean, sometimes we care if it's purposeful. But even if you have no idea what a copyright is, if there was a valid copyright, you had access to it, and it's substantially similar, and your use is substantially similar to the original creative work, and there's no defense, there is copyright infringement regardless if you even know what a copyright is or not. It's just bing, bang, boom, elements met, infringement. We don't care about intent, and that does not come into play in terms of determining if there is liability. Notably, it's called willfulness, not purposefulness, but willfulness does come into play when it comes to damages. Because if there's substantial damages, we'll talk about this later at the end when we talk about damages. But you could be on the hook for a lot of money if you acted willfully. Like, you knew that this was the property of somebody, you knew the ramifications of it, and you did it anyway. That is a big problem. So it's not like no intent is a defense, but having intent is a problem. The other thing, and I think this is more of a misconception than anything else, and it's kind of related. People think that once they're made aware that somebody's the owner and they take it down, either voluntarily or let's say you mark it. Let's say you have so let me just give you an example. Let's say I make phone cases and I have my proprietary phone case. It's deluxe, it's amazing. And I have these photos of the phone case that I took, right? And you make a competing model. And for whatever reason, maybe you worked with the manufacturer or something like that. Maybe it is a competing model. Maybe it's a black market good. I'm not gonna get into this stuff. But just know that like you selling the competing version, we'll just say for the sake of this hypothetical, totally fine. But you're lazy. And so you decided not to take any photos of the product yourself. You went onto my website and you copied my photos and you tied them to the sale, and you put them on your website for the sale of your product. They look pretty similar, so you thought it wouldn't be much of an issue. But I noticed that you took my photo. I sue you for copyright infringement. You take it down saying, I didn't even sell any of these products yet. It doesn't matter if it's like the infringement or the use of the infringement is done or didn't result in any money. The infringement still happened. And I think that's the other thing people don't understand is that it doesn't matter if it's continuous or not, so long as it happened and I have evidence that it happened and I bring that to a court, that is an open and shut case. And the last thing I want to mention is that companies, because they have a monopoly over their intellectual property, they can choose to enforce or not enforce their copyrights as much as they want, because it's really up to them. Whether or not it's a PR disaster is a completely different question, but I do think that that's something that we need to really kind of hit home about, is just because something is legal doesn't mean that it'll be the best decision for them long term, but also kind of the inverse of that. If they're doing something that you really disagree with, doesn't mean they're not enforcing their rights under the law. All right, so now let's talk about the big boy. Let's talk about fair use. We're past the infringement issue. The question is my use of your work fair use or not? Here are the 4 factors to determining if it's fair use. 1, the purpose and character of my use. 2, the nature of your copyrighted work. 3, the amount of your copyrighted work used. And then 4, the effect my use has on the potential market value of your copyrighted work. Those are the 4 elements. Me just saying them probably doesn't mean a lot to you guys, so let's kind of go into more detail here. Purpose and character of the use. What does that mean? So there's a number of ways to kind of, and here's the thing too, these 4 factors, I just want to also mention, these are to be weighed. So think of like a balancing scale, if all 4 factors weigh towards me, the infringer, then a court should rule that, as a matter of law, that it is fair use. If the factors weigh towards you, the copyrights holder, then it is not fair use, and I'm liable for infringement, assuming I don't have any other defenses. Notably, it's not 3-1 or 2-2. It doesn't. I could have only one factor weigh in my favor, but if it's so, like parody is a great example. If my work is very obviously a parody of your work, and to the point where it's just the first point, the purpose and character, if the purpose and character of my use is a parody, and all of the other 3 factors weigh in your favor, I am still very likely to win in this lawsuit. But parody is a very specific thing. It can't just be a Weird Al parody. There's several law articles on whether or not Weird Al's parodies are actual parodies, because the case law we have literally has to criticize, critique, analyze the original work that it is parodying. It can't just be instead of gangsters in paradise, it's Amish in paradise, right? It has nothing to do with it's not talking about the original song. And I think that's a really crucial thing about parodies that we don't understand. But kind of to go back to my point, if I made a parody, then I only have that one factor in my favor, but I win. It's fair use, right? But I think the inverse is also, I could foresee the inverse being true. I could have 3 factors weigh in my favor, and the judge still rule that my use is not fair. I could foresee that. So let's say, for example, let's use this video that you're currently watching as an example. Let's say instead of me talking about copyrights, I'm talking about family videos, generally speaking. I'm talking about family videos and how then they're some kind of societal, sociology-based point of view on the impact of culture in America. I have some kind of thesis on it. It's educational. Your home video is just shot of you and your family in your living room. It's 2-minute long video, so it's not super creative. My favor. And let's say there's no real potential market for it. You're not really in the market of licensing your home videos, right? It's a personal thing. You just kind of posted it on your Facebook page or whatever. But in the middle of this however many hour long documentary that I'm talking about, I put your 2-minute long home video in my video, unedited, in its entirety. I could totally foresee a judge say, yeah, those two or maybe 3 of the factors rule in your favor, but still infringement, right? These factors aren't to say, oh, you need to win all of them to be infringement or not infringement, or you need to have a majority of them to be fair use. They're just guidelines, and it's really much a case-by-case basis on how a judge will rule to determine if something is fair use or not. We talk about commentary videos and reaction content and whether or not that's fair use a lot on this platform. I think if people are just putting their face in the corner and just make visual facial reactions but aren't really commenting on it, that's not really adding much. That's usually not fair use, I would say. But there's some, very popular commentary channels these days will take clips from Netflix, from HBO, to talk about and review the thing that they're showing. And I think the video that they made would be lesser if they didn't show the specific clip that they're talking, whether it's even for comedy purposes, if they're showing how absurd something is in the movie or in the piece of content that they want to talk about. That impacts, because if you limit what you use to just what you need, you're creating a stronger argument for fair use, right? You don't have to use it's not the law says that you have to use the absolute bare minimum, but the more you go that route, the safer you are. It's a good rule of thumb to have from my experience. But at the end of the day, again, I really can't stress this enough. It really is a case-by-case basis. And even though the law, and I think I have the statute up at some point, I'll put it up again. Even though the law lists these enumerated examples here, commentary, news, that doesn't mean automatic fair use. Maybe it should, but it doesn't. And some jurisdictions weigh, if it is 100% commentary, critique, or 100% is news, some jurisdictions do weigh that more favorably towards fair use, but some treat it just like any other case. They just say, oh, it's just an example. It was just a preamble example to demonstrate what fair use could be. The law is the factors. Let's work on the factors. So I don't want to say, oh, it's commentary, oh, it's critique, therefore it is transformative and fair use. I don't want you to come to that conclusion either. The last thing I want to mention about fair use before moving on is there's been some movement in the law to kind of treat fair use as a sort of like anti-slap. So if you're familiar with slap suits, basically you sue somebody for defamation, even if you don't think that there's any basis for it. There were these anti-slap laws that were put into place to sort of say, hey, are these things met to the point where it was you could basically say, hey, this was a frivolous lawsuit. We'll just cut it out from the get-go, right? Fair use in some jurisdictions is starting to kind of be that way, where if something is so obviously fair use, it'll be mentioned in the motion to dismiss stage. And specifically to show that there was no claim stated. Now, for my fellow attorneys who know that that's a big deal, right? Because fair use traditionally is an affirmative defense. You have to raise that throughout the case, and you have to present evidence that it's the case, right? But if you're in a responsive pleading, your motion to dismiss, you present all the evidence to suggest that it is fair use, and there's no disagreement on the facts, especially if the facts were in the complaint, theoretically, if it was like in-depth pled. There have been some successful motions to dismiss, not necessarily on the grounds of fair use, but utilizing fair use to say there is no claim for infringement here because it is so obviously fair use as a matter of law. That's a really interesting development that kind of has a weird intersection with the federal rules that's still kind of developing. I think some jurisdictions think that that's a improper argument under failure to state a claim at the motion to dismiss stage. But some jurisdictions have bought it, and it's still it's definitely interesting, and it's curious to explore that aspect on a kind of a procedural level on when to raise fair use, because if you can raise it as early as possible, obviously you're saving so much money in litigation costs. So something I wanted to mention. All right, so we're in the last section here. I want to talk, I think it's going to be called Defenses to Benefits of Registration and Moral Rights. So I talked about this before, and I keep kind of saying it again as a joke, but there are defenses other than fair use that you can raise to show that there is no infringement. Obviously, the first defense that you could have is the statute of limitations is run. It's something that's not really, I think, brought up enough, but there is a statute of limitations. It's 3 years. So let's say you took a photo, I literally copy pasted it on my blog, and you did not, and you knew about it, because that was the thing, is that the time runs based on when you first find out about it. I can show that you knew about it, and then you dragged your feet, and then 4 years later you decide to file a lawsuit. 100% statute of limitations ran. Too bad, so sad. Another affirmative defense I could raise is independent creation. So let me take up that poster example I raised before about substantial similarity. And let's say because I'm pretty sure Tencent, the company behind Light of Motiram, is a pretty famous Chinese video game company. Let's take this up as an example here. And let's say the company on the right who made the poster for their competing game, let's say that they're in China, right? And China limits what websites they have access to. And they're able to show that no way, while they were in China, they had no way to access any website that had this poster on the left here. And they show that they made this poster, the second one, they made this poster 100% of their own independent creation. That is an absolute 100% affirmative defense, no infringement. The next thing I want to talk about, authors and licensing. So if you are a joint author and you don't like, let's say we wrote a book together. Like you wrote half, I wrote half, or let's just take a song. This is easier. I did the lyrics, you did the composition. We made the song together. We have equal rights to the whole. I turn around without your permission and I go to a record label that you cannot stand. They signed with an artist that you absolutely hate. You would say you would never be with that label in a million years. You can't sue me for infringement or the label because they got a valid license from me. So you can't sue, if you're joint authors, you can't sue each other. If I rightfully license it to somebody else, you can't sue them. There's also this argument of authorization and implied licensing. Like I talked about this before briefly, but this idea of contracts can be oral. Let's say we were working on something. Maybe I told you, do the script writing example again. Let's say I told you the script of a movie I had in my head and you decided to make a movie on it. And I was, very upset because you decided to make a movie on the script I had in my head. So I turn around and I make a book on it. I type it out. I type the words out. I make a book. I think from our conversation, you made it clear to me that, even before, maybe after you made your film, that, oh yeah, it was still your script. You should say something like that. I think, oh, well, I can now do what I want with the script that I told him about. So you think, I think I have authorization to go out and do this thing, which is make a book, right? And I meet all the requirements because, I'm not going to go into the details, but I meet all the requirements for authorization or an implied license. I am not on the hook for that book I wrote. That was 100% valid in this particular example. Last one I want to talk about, first sale doctrine. So when you sell your book that you wrote, I buy your book. When I buy a copy of your creative work and I own it and I'm maybe sharing it around with friends or something, so long as I'm not violating any of the exclusive rights that you have through my copy, I can do whatever I want with my copy that I paid for under the First Amendment. Even if it's something that you disagree with. And there's some caveats on that, and we'll get into that with moral rights. So long as I'm not infringing on it through what we talked about earlier, I can do whatever I want with my copy. But that kind of leads to the next subject. Let's talk about moral rights. So normally, in the past, this could have been a more interesting section, but over time, moral rights have really diminished, but they still do exist. So what do I mean by moral rights? Well, two examples I like to give are, let's say you are a really famous artist. You do oil paintings and you've done a beautiful oil painting and then you die. And now your heirs have inherited that painting. Still, the copyright's valid on it. It has 70 years haven't passed. They auction it off to pay for the funeral or something, whatever. and they sell it for something ridiculous, like $1 million. Great. They're ecstatic. The painting was so beautiful, it probably belonged in a museum. I buy that. I'm the winner of that auction. I bought the painting. I take it and I deface it immediately. I draw clown faces on it. I draw a little poop like emoji on it or something stupid, right? And I'm painting on it in like with my own oil, and I'm like taking a knife and I'm like stabbing the oil painting that the oil paint that was originally put on it, and I'm defacing it in a way that cannot be, it is irreversible, right? Do you, as the heir of the artist, have a claim? The answer is no. And again, that kind of goes back to that first sale doctrine. This was now my painting. You have the rights to that. You have the rights to the intellectual property, so you could remake that oil painting again if you as the heir are so skilled to be able to recreate it identically or substantially. But that's not the intellectual property I violated. I violated just the copy that I bought, and I was I was expressing myself when I did that. That is within my First Amendment rights to do so. It doesn't sound right, does it? Like, that feels wrong. And a very similar set of circumstances where there are moral rights is, let's say, and to be fair, I think there used to be a time where that might have been the case, but over time, various case law has whittled away at it. But an example of moral rights that are 100% still on the books, still real, is something called tarnishment. So let's say, again, we'll take the example of a beloved character, Spider-Man, and Spider-Gwen is depicted here. And let's say I am a very notorious, infamous porn studio, and I look at these two models here and I say, you know, I really want to make a porn video while they are in these costumes. I won't call it Spider-Man because of trademark law, but they'll be in these costumes and maybe the Green Goblin will show up and mess up the sex scene or something like that. Now, I shot that myself. Obviously, there's a whole element of infringement with substantial similarity. We talked about that with cosplay. But even if I can say, oh, it was transformative, or I'm making a statement or something like that, it was so transformative that it was fair use. Let's say I say that, and we'll just say I meet the factors. I don't think I would, but let's just say for the sake of argument, I meet the factors such that there is no infringement here, because I don't want to harp on the infringement angle. You would still have a separate claim under what's called tarnishment, where we know you have a valid copyright in the work. I utilize the work without your permission, don't have a license, and I did it in a way that was obscene, that violates your morals, such that my First Amendment rights are not superseding that. That is 100% a form of moral rights that does still exist. And it's the most extreme example I can think of, but I think it's the most apt one that we can kind of see where that's coming from. Last thing I want to talk about is procedural stuff. Boring stuff, but very important. Registration. So, people think, oh, I need to copyright my stuff. Well, we talked about before, when you make the second you made the thing, it has a copyright. So what is registration? What is that? Why do we care about registration at all? Well, a couple reasons. One, a copyright registration allows you to sue for infringement. Some people don't realize this. You need to have a valid registration to bring a lawsuit for infringement. Now, so long as you get that approved, and if you try to bring a lawsuit before that happens, it'll be dismissed for lack of standing. You need to have a registration to even bring the lawsuit in the first place. Related, you're going to want to register the copyright as soon as possible, either before you publish, within 3 months after publishing, or within 1 month of noticing somebody has infringed on your work. The second you file for for the copyright, that'll be the effective date of the copyright. That's fine. It'll take months for it to be approved. So during that span of time, you can't file the lawsuit. But as long as you file for the registration, again, before it published, within 1 month, or within 3 months after publishing, or after 1 month of noticing the infringement took place, and that those last two, like if there's overlap, so within that 3 months after publishing, it's the shorter of the two. So you want to file it within that 1 month after noticing the infringement. So again, earlier the better. Probably want to do this before you publish it to the public in the first place. But the reason why you want to do that is for two things: statutory damages and the recoupment of attorney's fees. You need to have that registration during that window to be eligible for these things. Attorney's fees, we talked about. Attorneys love it. It makes these cases worthwhile for us. The other thing, statutory damages, the other thing, statutory damages, that relates to, literally in the statute, it tells you how much you can recoup for, as little as $750, I think, to $30,000. But if it is willful, max of $150,000. And that's per infringement. So if there's multiple infringements, there is a way to potentially show you're going to get a lot of money recoupment for this. Because again, the idea was, we really wanted, when the statute was written, Congress was saying we really want to disincentivize infringement. How do we do that? We instill this very draconian preventative measure, this punitive measure of damages. So that's why you want to get registered, and that's why you want to get registered as soon as possible. Other benefit is presumption of validity. So remember before with infringement, the two elements, one was a valid copyright, the other was unlawful or illicit copying. When you have a valid copyright registration, you have a presumption of validity and in that copyright. And unless that, which can be overturned, but the burden shifts over to the defense, the person you're accusing of, to show that registration was invalid. That pretty much covers everything I wanted to talk about in this first part of this video. And I'm sure I've left out a lot of stuff. Again, every single one of these topics I mentioned could have been its own separate lecture in a course on copyrights. And how I even talk really about the new stuff relating to AI and like that whole debate. Maybe in the future I'll make a separate video on that if you guys are interested. But as a first part one, I think I did a good job laying the groundwork for part two. I mean, I've already been here talking. This is gonna be shorter because I'm gonna trim this down, obviously, but I've been talking for 1 hour and 43 minutes already, so this is plenty long as it is. I would love to jump right into part two and start talking about what those problems are and solutions, but I think it's best if I stop here, give you guys some time to kind of mull over this stuff, maybe ask some questions in the comments, and I can bring those up maybe in the next part. But I think that's going to do it for this one. Hopefully you found this interesting and informative, and please stay tuned for part two, because part two I'm 100% making. I'm going to start recording this like right away, but the following week I'm going to post it. But again, if you have any comments or anything really just didn't make a lot of sense, or things that you think would be problems, drop them in the comments below, and I might talk about it in the part 2. But yeah, that's it for this one. Hope you found it interesting, and I'll see you in the next video.